Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
A father is accused of raping his 8-year-old daughter. What charges can be filed against him? And why is the proper name of the charge important? Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 26th of October 2024, and today we talk about the case of People versus ABC 260708, decided on January 23, 2024. It's an unbanked decision penned by Supreme Court Associate Justice Mario V. Lopez. Joining us to talk about this case is Attorney Dean Ace Pamaran, Judicial Staff Head from the Office of Associate Justice Lopez. Hi, Attorney Dean. Thanks for joining us. Welcome to the Supreme Court Podcast.
Hello, Mike. Salamat. Thank you.
Thanks to you for joining us in this virtual call. As you know, the work was suspended at the Supreme Court in some other courts due to Tropical Storm Christine. I hope you're doing okay. Staying safe and dry, Attorney Dean.
I'm fine, Mike.
All right. So let's talk about this case. Quite a gruesome case involving the rape of an 8-year-old by her own father. Tell us a bit more about this case. What happened here?
Attorney Mike, this case is about a father who raped his daughter, his minor daughter. And in one occasion, 2 sexual abuses were committed. One is rape through sexual intercourse, and the other is rape through sexual assault. The father used force, threat, intimidation against the victim, and after consummating the bestial acts, the father threatened the victim not to tell anyone. What's interesting about the case is the witnesses who saw what happened. And this is the older sister of the victim.
What were the evidence presented that the father supposedly raped the daughter?
Okay, so the primary evidence presented by the prosecution is a testimony of the minor victim. Aside from the testimony of the victim, the older sister of the victim likewise testified before the court, as well as documentary and physical evidence, kasama yan. So, police blotter, medical legal report, the birth certificate, and the admission of the father as to their relationship. The medical legal report was presented by the prosecution to prove the fact of rape, the presence of hymenal lacerations. Although it is not conclusive whether or not rape happened, it will corroborate the incident. As for the birth certificate, it is presented by the prosecution to prove the elements of age and the relationship of the offender to the victim. So these are important in prosecution of rape.
All right. Attorney Dean, what was the defense of the father?
The father's defense is very simple, a denial. The father explained that at that time of the incident, he was merely baiting his daughter, pinapaliguan.
But was rape established in this case in the 3 courts that it went through? I understand that it went through the Regional Trial Court, then to the Court of Appeals, and then finally at the Supreme Court. So was there a finding by the courts that there was really rape here?
The RTC, the Court of Appeals, and the Supreme Court have a unanimous finding that rape was committed. For instance, in the Regional Trial Court, it gave credit to the testimony of the victim as well as the documentary evidence of the prosecution. The RTC explained that the minor victim has no ill motive to testify against her father. On the other hand, the father's denial is uncorroborated, meaning there are no witnesses who can prove that the father merely baited his daughter. And the Regional Trial Court ruled that this denial is weak and self-serving.
So there's question that there was rape here, but there were differences in terms of how the Regional Trial Court, the Court of Appeals, and the Supreme Court characterized the rape involved. Can you walk us through how the decisions differed in terms of what was the nomenclature or the name of the charge of the crime that was supposedly perpetrated by the father?
Yeah, actually, this is the meat of the decision in People versus ABC about the accurate taxonomic designation of the offense committed by a father who raped his minor daughter. So, let's start with the Regional Trial Court. The Regional Trial Court convicted the father with a crime denominated as qualified rape because the special qualifying circumstances of minority and relationship are present. So again, minority because the victim is a minor, relationship because the victim is the daughter of the offender. In contrast, the Court of Appeals designated the crime as qualified statutory rape. The Court of Appeals explained that aside from the special qualifying circumstances of minority and relationship, the victim happens to be below the statutory age. And at that time, the statutory age is 12 years old. So any victim below 12 years old, the crime should be denominated statutory rape. So, given this statutory age and the twin circumstances of minority and relationship, the Court of Appeals ruled that the proper nomenclature should be qualified statutory rape. So if you will see, the RTC, qualified rape, the Court of Appeals added the word statutory. QSR, qualified statutory rape.
And what happened when it reached the Supreme Court?
Now, when it reached the Supreme Court, the justices dissected the history of rape and at the same time surveyed the different divergent jurisprudence. Because there are cases wherein the Supreme Court called the crime committed simply as qualified rape. On the other hand, there are also set of cases which called the rape qualified statutory rape. So there is now a confusion. What should be the correct designation? You know, Mike, nomenclature is very important because if you will read the introduction of this decision, the ponente, Justice Mario V. Lopez, stresses that the study of crimes begins with an understanding of its definition, nature, and penalty, and ends with an accurate nomenclature or designation of the offense. Why? Because we cannot just give names to crimes as we wish. The nomenclature must reflect the principles of criminal law. Otherwise, if we will name crimes as we wish, it will lose its meaning.
And of course, Attorney Dean, it's the legislature who actually defines the crimes, right? It's
Correct.
the justices in the Supreme Court.
It was also mentioned in the decision that the definition, nature, and penalty of the crime are essentially legislative in nature. However, it doesn't stop the court from baptizing a crime its own name, especially if the law does not provide for any designation or nomenclature. So this is also a doctrine in this case.
So, right, you've pointed out how important nomenclature is. Can you discuss to us very briefly, Attorney Dean, the historical background of the evolution of the definition of rape? What were the major changes to the acts that were defined as rape throughout the years? I understand there were several changes.
Yes, let's start with the original provisions of the Revised Penal Code. Under the Revised Penal Code, rape is classified as a crime against chastity, and only women can be victims of rape. Under the original provisions of the RPC, rape may be committed through force, intimidation, or when the victim is deprived of reason or otherwise unconscious, or when the victim is below 12 years old. So under the original provision of the RPC, the concept of statutory rape is already present. In 1993, Republic Act number 7659 was enacted. At that time still, rape is classified as a crime against chastity. Again, only women can be victims. But this law, Republic Act 7659, introduced the qualified form of rape. This time, the law enumerated qualifying circumstances that will make the crime more severe or the penalty higher.
What are these circumstances?
So, for example, the circumstances of minority and relationship, like what happened in this case. The offender is a father and the victim is a daughter. Another qualifying circumstance is when the offender is a uniformed personnel, a police or a military. Another qualifying circumstance is when the rape is committed in full view of the husband or the children of the victim. Other additions are when the victim is below 7 years old. So if you will observe, Mike, from the original provision wherein the victim is below 12 years old, the crime of rape will become qualified when the victim is below 7 years old.
Okay. Statutory below 12, But if
Yeah.
it's below 7, it becomes qualified.
Qualified. So this distinction is important in People versus ABC. Later on, we'll discuss about that. So if you want to know more about other circumstances, qualified form of rape is when the offender knew that he is afflicted with AIDS and when mutilation of the victim occurred by reason or on occasion of the rape. Then in 1997, a significant change happened in the crime of rape through Republic Act number 8353. This time, from being a crime against chastity, rape is reclassified as a crime against person. This is very important because this time, both sexes may be victims of rape. It is no longer limited to women. Another important amendment under Republic Act number 8353 is the introduction of the concept of sexual assault, as well as the introduction of the concept of marital rape. Because before, there is an idea that the husband cannot be guilty of raping his wife. But under this amendment, the wife was forced by the husband to have sexual intercourse with him, may be liable or may be charged with rape. Then also, lastly, in this law, additional qualifying circumstances were mentioned, like when the victim is pregnant and when the offender has knowledge that the victim is mentally disabled. So these are additional amendments under Republic Act number 8353. But the latest amendment happened in 2022 through Republic Act number 11648. So the statutory age now from 12 years old was raised to 16 years of age. And the term woman is already deleted. Under Republic Act number 11648, the law used the term person. The purpose is to emphasize that this crime of rape is no longer limited to any gender, but it is a crime against a person. So, yan yung mga, so these are the important changes under Republic Act 11648. So, if I may add, there's also the so-called Romeo and Juliet provisions. Are you aware of the Romeo-Juliet provision?
No, not at all. What is that?
Yeah. The Congress called it during their deliberation as the Romeo and Juliet provision. Remember, RA 11648 raised the statutory age to 16. However, the law provides that there shall be no criminal liability if the victim is below 16 years old and the age difference between the victim and the offender is not more than 3 years old. And so it's not more than 3 years. For example, if the victim is 15 years old and the offender is 17 years old, the law provides this time that there shall be no criminal liability provided the sexual action is consensual, non-abusive, and non-exploitative. But there is an exception. If the victim is below 13 years old, the Romeo and Juliet provision will not apply.
So this provision actually says it was a consensual affair, and even if I'm a minor, as long as I'm between 13 and 16, there should be no rape. That's it kind of complicates things, but it provides nuance to rape. So now we have a lot of things to think about. But in this particular case, we're still talking about the previous law, right? We're talking about the law where the statutory rape threshold is still 12 years old when this incident happened, right? But what I want to ask Attorney Dean is, what's the impact of having all these additional circumstances to qualify rape? Does that mean more instances can now lead to a heftier penalty if you're proven guilty of rape?
Actually, these modifying circumstances are testaments to the perversity committed by the offender against the victim. Because if these circumstances are present, not only the name is changed, but also the penalty. The penalty is death, the capital punishment.
No, let me turn now to the difference between statutory rape and qualified rape. Earlier we touched on this, but let's go deeper into this discussion because I believe this is the meat of the case. What's the difference between statutory rape and qualified rape?
Okay, so we can distinguish statutory rape from qualified rape under three criteria. Number one, as to the modes of commission. Number two, as to the circumstances present. And number three, the prescribed penalties. So let's start with statutory rape. So statutory rape is essentially carnal knowledge of a woman below the statutory age. So it depends on the time the incident happened, whether before or after Republic Act number 11648. So it's either below 12 years old or below 16 years old. So like you mentioned earlier, this case happened before the enactment of Republic Act number 11648. So the statutory age remains below 12 years old. So in statutory rape, you need to consider first the age. So if the victim is below 12 years of age, it will be considered statutory rape even if there is no proof of force, threat, or intimidation, or even if the victim consented to the sexual act. Why? Because a person below 12 years old is presumed to have no discernment and is incapable of giving intelligent consent. In fact, Mike, the Supreme Court also ruled that sexual intercourse with a mental retardate whose intellectual age is below 12 years of age, even if her physical age is more than 12, is still considered statutory rape. And the prescribed penalty for statutory rape is reclusion perpetua. On the other hand, qualified rape is sexual intercourse with a woman, not necessarily a minor, where the aggravating circumstances, the special qualifying aggravating circumstances that we mentioned earlier are present. So you will consider here Republic Act number 7659, which listed the complete modifying circumstances, the special qualifying aggravating circumstances. So Republic Act number 7659 together with Republic Act number 8353. So if you will dissect these circumstances, these are all related to the relationship between the offender and the victim. Like minority, we will also consider the moral ascendancy or influence between the parties. Like what we mentioned earlier, the offender is a uniformed personnel, or when there is abuse of authority on the part of the accused, or when ignominy in the commission of the offense is present. So basically, these circumstances depends on the conditions of both the victim and the perpetrator.
Now, in this case, Attorney Dean, so there was an issue between calling it qualified rape and qualified statutory rape. We can see that the reason why the CA probably thought that this is called qualified statutory rape because both the circumstances under qualified rape and statutory rape are present because the daughter here was found to be 8 years old. So ideally that should be statutory rape, right? And then you also have the other circumstances that would qualify it as qualified rape. But how did the Supreme Court come to the conclusion that this should be called qualified rape? There's no such thing as qualified statutory rape.
All right, so the Supreme Court started with a survey of jurisprudence, where the origin of the term qualified statutory rape. And the Supreme Court discovered that the term qualified statutory rape was actually first mentioned in a dissenting opinion. Imagine that, di ba? The term qualified statutory rape was first mentioned in a dissenting opinion and it was carried over by subsequent decision, this time, majority opinion naming that crime qualified statutory rape. Then, the court surveyed again the jurisprudence and found out a different set of cases wherein a plain qualified rape was used without the word statutory rape. So, as mentioned earlier, there is now a confusion because of this divergent jurisprudence. And to solve this mystery, I call it mystery because there is doubt what is the accurate nomenclature, whether qualified rape or qualified statutory rape. So, the Supreme Court resorted to the principles of criminal law. the bank emphasized that if we will baptize a crime with a particular name, it should follow the basic precepts and principles of criminal law. And the key to solve this problem are the aggravating circumstances, the proper classifications of aggravating circumstances.
Right. You mentioned aggravating circumstances. There's a discussion in the case here of different kinds of aggravating circumstances. I think it might be important for us to discuss. There are about 6 of them, Attorney Dean. What's the difference between, say, a generic aggravating circumstance, a specific aggravating circumstance, then you also have a qualifying aggravating circumstance, an inherent aggravating circumstance, a special aggravating circumstance, and you also have a special qualifying aggravating circumstance. So that's quite a lot. So let's go through them one by one.
Just a background there. So this doctrine in this case about the classifications or kinds of aggravating circumstances is very important to law students because when I was still studying, there are only 4 or 5 aggravating circumstances. But this case added the term special qualifying aggravating circumstances. So let's now distinguish these different aggravating circumstances. So this is important not only to law students but also to professors of law. So they should update their notes. So let's start first with the general effects of an aggravating circumstance. So an aggravating circumstance represents a greater degree of malice on the part of the offender, meaning the commission of the crime is very vicious, the motivation of the accused is very perverse, the means employed or the personal circumstances of the accused may contribute to this greater degree of malice, viciousness, and perversity. So, as mentioned, aggravating circumstances may be generic, specific, qualifying, inherent, special, and special qualifying aggravating circumstances. So, let's start with a generic aggravating circumstances. The word generic means these circumstances are applicable to all kinds of crimes. And the effect is to increase the punishment. So the formula is greater perversity of the offender is equivalent to higher penalty. But considering that this is only a generic aggravating circumstance, the punishment may be increased only up to the maximum period of the prescribed penalty. It cannot go beyond the prescribed penalty. Another characteristic of a generic aggravating circumstance is that it can be offset by an ordinary mitigating circumstance. So, you must be familiar with the concept of ordinary mitigating circumstance. So, the effect of a mitigating circumstance is directly opposed to a generic aggravating circumstance. So, if an aggravating circumstance increases the penalty, a mitigating circumstance will result in the reduction of the penalty. So if these circumstances are both present, there will be so-called offsetting. And this happened only between a generic and ordinary mitigating circumstance.
Right. So this is under Article 13 and Article 14 of the Revised Penal Code. And first-year law students taking Crim Law 1 might be very familiar with these circumstances, Attorney Dean. So, but what about the specific aggravating circumstance and the other types?
On the other hand, specific aggravating circumstances are applicable only to a particular crime as expressly provided by law or jurisprudence. But the effects are the same. The effects of a specific aggravating circumstance are similar to the effect of a generic aggravating circumstance. So what are these effects? Both generic and specific aggravating circumstance will not change the character of the offense. They can only increase the penalty but not beyond the maximum period provided by law. More importantly, both generic as well as specific aggravating circumstance may be offset by an ordinary mitigating circumstance. So technically, the distinction between generic and specific is generic applicable to all crimes, specific applicable only to particular crimes.
What about qualifying aggravating circumstance and inherent aggravating circumstance?
Okay, so this time, it is called a qualifying aggravating circumstance if the presence of this circumstance will change the nature or designation of the crime. It also warrants the increase of the imposable penalty even beyond the period prescribed. So it can go as to the next higher degree as provided by law. So qualifying circumstance must be defined by the law.
Attorney Dean, for example, let's cite an example for a qualifying aggravating circumstance. If the killing, for example, is attended by certain circumstances, that would qualify it to murder. So is that an example of a qualifying aggravating circumstance?
Correct.
So
Yes, that is the common example in law school. So if the killing is attended with treachery, for example, or evident premeditation, the crime will be classified as murder. So not merely homicide. Because in homicide, this is only plain killing without any qualifying circumstances.
Right. What about the other types, Attorney Dean? We're halfway through the six enumerated circumstances.
Let's now discuss inherent aggravating circumstances. So inherent aggravating circumstances necessarily accompanies the commission of the offense. For example, in the crime of arson, fire is not an aggravating circumstance. It is an element. It is inherent in the commission of arson. Another thing is fraud, which is mentioned as aggravating circumstance under Article 14. But if the crime is estafa, fraud will not be appreciated because fraud is inherent in the commission of estafa. So, inherent aggravating circumstances, these are circumstances which are actually an element of the crime, which are actually elements of the crime.
Right. And what about the special aggravating circumstance?
So, special aggravating circumstances arise under special condition to increase the penalty for the offense. Unlike a generic and specific aggravating circumstance, a special aggravating circumstance is special because it cannot be offset by any mitigating circumstance, by an ordinary mitigating circumstance. So, examples are quasi-recidivism, the rules on complex crimes, mistaken in identity, and taking advantage of public position and membership in an organized syndicated crime group. So, these are all considered special aggravating circumstances. Again, they cannot be offset by any ordinary mitigating circumstance.
So they can't be offset, but they increase the penalty. At the same time, they don't make it another crime.
Yes.
Right. And so finally, we've come to the most important part of this case, a special qualifying aggravating circumstance.
Lastly, a special qualifying aggravating circumstance. So, take note of the correct term. Special qualifying aggravating circumstance includes those mentioned in Republic Act number 7659. So, you must read this particular law. It is called a special qualifying aggravating circumstance because the penalty is death, capital punishment. So, unlike special aggravating circumstance, the penalty is not necessarily death, but can increase the penalty even to the period or next higher degree, but not necessarily capital punishment. But the moment the penalty imposed or the imposable penalty is death, that circumstance is called special qualifying aggravating. So, if you want me to give examples, so in kidnapping, so when the kidnapping is committed for the purpose of extorting ransom, the penalty is death. Or when the victim is killed as a consequence of kidnapping, the penalty is also death.
Of course, we're talking about death as an imposable penalty as opposed to an enforceable penalty, Attorney Dean, now that we're not implementing the death penalty, right?
So, under the new law, death penalty can no longer be imposed. So, in lieu of death penalty, the imposable penalty will be reclusion perpetua if the crime is a violation of the revised penal code, or life imprisonment if it is a violation of a special penal law.
Very interesting discussion so far, Attorney Dean. And just to tie it back to the case, how did the Supreme Court, taking into consideration all these discussions about qualifying circumstances and the distinction between qualified and statutory rape, how did it finally rule on what happened to the case of the father and the 8-year-old daughter?
Okay, so let's now discuss. So, the Supreme Court abandons the term qualified statutory rape. Why? Because after discussing all these kinds of aggravating circumstances, the court ruled that if the victim is a minor and the offender is a father, the crime must be called qualified rape. You can no longer consider the minority of the victim because it is already absorbed or inherent in the qualified form of rape called qualified rape. However, the Supreme Court added the term minor to the term qualified rape. So the complete and correct nomenclature should be qualified rape of a minor. The purpose is to stress that the victim is a minor because, Mike, there are other forms of qualified rape, as we mentioned earlier. And I mentioned that the victims in those cases are not necessarily minor. So, if the circumstances that will qualify rape are present and the victim is a minor, the Supreme Court ruled that the proper term should be qualified rape of a minor, not qualified statutory rape.
I'm trying to understand. Sorry, I'm trying to understand why that should be the case. If it's clearly below 12 at that time, it's statutory. Why not call it qualified statutory rape?
Again, Mike, the Supreme Court ruled that qualified statutory should be abandoned because it is not in accordance with the basic principles of criminal law. Again, let's go back to the concept of inherent aggravating circumstances. In statutory rape, the circumstance of the victim being below 12 years old or below statutory rape is inherent to the crime. And it is a rule in criminal law that a particular circumstance, like minority, cannot be appreciated twice because that will be prejudicial on the part of the accused. So it can only be appreciated once. So, if the circumstances of qualified rape and statutory rape are present, the Supreme Court ruled that the proper term should be qualified rape of a minor if the victim is a minor. Why? Because the minority of the victim already absorbs the circumstance of the victim being below 12 years old. Another example, Mike, remember also that another form of statutory rape is when the victim is a mental retardate with a mental capacity of a child below 12 years old. And if you will recall also, one of the qualified form of rape is when the offender knew that the victim is suffering from mental disability or mental retardation. So again, the Supreme Court ruled that we cannot appreciate mental retardation twice. It can only be appreciated once. So between statutory rape and qualified form of rape, the Supreme Court ruled that the mental retardation is deemed absorbed or should no longer be appreciated. So when you call it qualified rape of a minor, deemed written is the fact that the minor or that the victim has a mental capacity below 12 years old or is a mental retardate. So that is the formula there. You cannot appreciate one circumstance twice.
Mm-hmm. And how important is the age of 7 or 8 in this case? Because the charge actually claims, or the charge alleged that the victim was 7 years old at the time of the commission of the crime, but based on the facts of the case, it seems that she was actually 8 at that time. So how is the age of 7 years old important or significant in this case?
Okay, so if it is alleged and proved during trial that the victim is below 7, the crime is automatically qualified rape because that is one of the qualified form of rape under the amendments. On the other hand, if the victim is 7 or 8, that will only amount to statutory rape. Because under the amendment also, if the victim is below 12 or below 16, as of now, the crime must be called statutory rape. However, if the victim is 7, 8, or a minor, and there is an additional circumstance on the part of the offender being a father or a relative, that will now be called qualified rape of a minor. So can you see
Yes,
the
yes. There's a lot of nuance in rape, Attorney Dean. I think I will need to review, read again the case, and listen again to this podcast. But this has been a very, very interesting discussion, Attorney Dean. I'm learning a lot about the whole nuance of rape. So, rape now isn't just about a woman being violated by a man. It applies to all genders, and at the same time, there are different circumstances you have to look into to appreciate the true nature of what really happened. Is it qualified rape? Is it statutory rape?
To help the students as well as the professors of law, even this decision is a very long discussion. The Supreme Court summarized itself. Take note of the guidelines.
Sure.
Yeah,
Let's discuss that.
this court, the Supreme Court and Bank, for clarity and uniformity, fix the guidelines as to the proper designation of the offense when both elements of statutory rape and qualified rape are present. So you can skip the discussion part. You can jump to these guidelines. So it is found in page 27, maybe 28 of the decision.
So, Attorney Dean, how about the civil liability of the accused? Will the nature of the charge, the proper nomenclature, matter in terms of the civil liability?
Yes, it is also important, Mike. So the civil liability in this case, the Supreme Court opted to increase the civil liability from 100,000 to 150. By the way, Mike, normally in qualified rape cases, the Supreme Court only imposed 100,000 civil indemnity, 100,000 moral damages, and 100,000 exemplary damages. But in this particular case, given the depravity of the crime and to achieve the purpose of preventing the parents from sexually abusing their children, the court opted to impose or increase a civil liability of 150,000 pesos for civil indemnity, moral damages, and exemplary damages. Again, the presence of aggravating circumstances reveal a greater degree of malice and viciousness on the part of the offender, such that it must also be reflected in the award of civil damages.
Right. And also, just so we don't forget, there was also another act here that was also considered sexual assault aside from a qualified rape of a minor. So all in all, we have actually two instances here that were punished as rape, Attorney Dean, right?
Yes, correct. Rape through sexual intercourse and rape through sexual assault.
All right, Attorney Dean, thank you so much for joining us today. Very important discussion. Certainly a very important addition to our jurisprudence. So thank you so much for joining us today, Attorney Dean.
Thank you, Mike.
And if you wish to read the full text of the court's decision, you can go to the Supreme Court website and e-library. Just search for People versus ABC 260708, GR number 260708. Here's Steph Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
At the Supreme Court this week. The Supreme Court sentenced to life imprisonment a Korean pastor for human trafficking. Si Young-oh of the Korean Christian Presbyterian General Assembly was convicted of qualified trafficking under the Anti-Trafficking in Persons Act for recruiting minors under false pretenses to subject them to forced labor. In another trafficking case, the court emphasized that evidence showing a victim's sexual predisposition or past sexual behavior is not admissible in any criminal proceeding involving child sexual abuse, under the Sexual Abuse Shield Rule found in Section 30, Paragraph A of the Rule on Examination of a Child Witness. The Sexual Abuse Shield Rule aims to protect victims against invasion of privacy, potential embarrassment, and sexual stereotyping that happen when intimate sexual details are disclosed in public. This protection also encourages victims to speak up against their abusers. The Supreme Court welcomed the enactment of 8 laws establishing additional trial courts in the country. Republic Act numbers 12029 to 12036 created 21 additional regional trial courts, 2 municipal trial courts, and 3 metropolitan trial courts in different cities and municipalities in Luzon, Visayas, and Mindanao. Interested participants for the Metro Manila leg of the proposed amendments to the Rules of Civil Procedure regional consultations to be held on November 8, 2024 at the De La Salle University, Manila may now register until October 31, 2024. Registration is also ongoing for the final leg of the proposed amendments to the Rules of Criminal Procedure regional consultations in Manila to be held on November 7, 2024. Participants may register until November 3, 2024. The regional consultations aim to engage various stakeholders, including judges, legal practitioners, and the academe, in discussing proposed amendments to the Rules of Civil Procedure and Criminal Procedure. To register, visit the Supreme Court website. The Supreme Court issued a temporary restraining order, or TRO, against Commission on Election Resolution number 11044-A, disqualifying Mandaue City Mayor Jonas Cortez, former Albay Governor Noel Rosal, and Cebu City Mayor Michael Rama from participating as candidates in the 2025 elections following their respective dismissals by the Ombudsman. Their dismissals included the accessory penalty of perpetual disqualification to hold public office, but which the three argued are not yet final. In another case, the court affirmed the COMELEC's disqualification of Noel Rosal as governor of Albay Carmen, Geraldine Rosal as mayor of Legazpi City, and Jose Alfonso V. Barizo as councilor of Legazpi City during the 2022 national and local elections. They were disqualified for violating the Omnibus Election Code in disbursing and releasing government funds during the prohibited period before a regular election.
And that's your Supreme Court this week. I am Tiffany Doblatran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Jen Tuazon Erania as researcher, Don Ryan Balza and Victor Laranio as sound editors, and Ty Flores as web editor.